The information made available via this podcast is for informational purposes only and not for the purpose of providing legal advice. You should contact your attorney to obtain advice with respect to any particular issue or problem. Use of and access to this podcast or any of the email links contained within its website do not create an attorney-client relationship between Michael Dockins, Shoemaker, Loop, and Kendrick, and the user or listener. The opinions expressed at or through this podcast are the opinions of the individual author and may not reflect the opinions of the Shoemaker firm or any other attorney.
Hey everybody, it's Mike Dockins, the Gimmick attorney, coming to you with another episode of Wrestling with the Law. I believe this is episode 7, and I decided to do another Ask the Gimmick attorney because I wanted to try to get things back on schedule where episodes will drop mid-month or close to mid-month after a couple months of weird travel and work and so on and so forth. So anyway, without further ado, let's jump into it. First question comes from Chip Maxey, and he asks, there's an alleged hush-hush agreement between WCW and Paul Heyman over his firing back in the early 90s. His questions are, do those some sort of statute of limitations? So I think what he's saying is, those sort of agreements have a statute of limitations? And since WCW is no longer in business, technically the hush-hush, is it voided? There's not a statute of limitations if it was by contractual agreement. If it was a verbal agreement, there is probably common law in whatever area. Since it was WCW, it'd probably be Georgia law or whatever law Turner Media usually relied on. And if they were a Delaware company or something like that, it might be Delaware law, but I digress. There's no statute of limitations. You know, it is what the contract says or what common law says if there was no written contract. And though WCW is not in business, there's a very good chance and very likely that what WWE took, if they took anything with respect to talent and things like that, they might have adopted some contracts. They might have been assigned to them. They kind of stepped into their shoes. I don't think that's the case. I think what WWE got just was some assets and some intellectual property and things like that. But those agreements might have been rolled into Turner Media or something like that. So they could still be in force and effect. It's hard to say. We don't know because there isn't a contract that any of us can see. But generally speaking, if there's a non-disclosure agreement or something like that, it can be without a termination date. It can just be as long as such things need to remain confidential or until one party releases the other. So my guess is, more than anything, it's probably an embarrassment sort of thing for Heyman, if that's the case, and he just doesn't want to talk about it and have it out there in the public. Next question comes from Michael McClanahan. What are your thoughts on wrestling companies developing characters that utilize costumes that allow them to keep their face hidden, allowing multiple wrestlers to portray the same character? Manic and Impact, for example, or Sin Cara in WWE, and as I'd point out, Doink. We've seen this have mixed results over the years with crowd response. However, do you think investing in more character-based wrestlers is a good way for companies to maximize their intellectual property? It's an interesting question. I think that the only times that WWE or a wrestling company having intellectual property and actually using it the way they claim to use it in the trademark office or in public disputes and lawsuits and things is to have a mask or something where the person can actually change. While the intellectual property associated with a gimmick or a stage name or whatever WWE owns and the wrestler when they leave isn't allowed to take with them, while it's technically true, they've never successfully put a gimmick on somebody else and had it get over and had it be just as popular, except for the Doinks and the masked characters, for example. And that's because people, when they can see a face, associate it with a real person. And so they, as a source identifier, which is what a trademark is, as a source identifier, they expect the source to be the same person, to provide a particular style of matches or promo or moves or something like this. So do I think that they should maximize that? Probably. I think there's at some point where someone will challenge WWE or will challenge a smaller wrestling company about them keeping their IP and kind of holstering it and not allowing them to take it with them, even though they're the ones who got the IP famous. And they'll challenge it and they'll win. But, winning against WWE right now would be pretty insurmountable. That's a fight they would fight to the death and tie up in litigation and tie up in appeals for, a decade or more. So it's not going to happen anytime soon. So I guess practically speaking, they don't need to do that. And they probably wouldn't do that. And by that, I mean, have more kind of masked or makeup based characters so that the IP can be pushed. As far as character based versus real name, doesn't really matter. I think we're in an era where having real names and treating them like real people is where we are. And having a gimmick, at least sometimes, kind of looks silly, like having zombies around the ring. In the 80s and 90s, why not? That part of the story, we're kind of over the top. We're kind of superheroes and comic book heroes in a wrestling ring. But when we got more reality based, that now kind of looks very out of place and looks very silly. And people have been pretty critical of it. The other question by Michael was, do you believe a character's intellectual property is strengthened by co-branding, such as Randy Savage and Slim Jim? Do you see any drawbacks to co-branding, and in what circumstance, if any, would you advise people to stay away from it? I don't know that I would say that that's co-branding necessarily. I think that's just, it's a licensing thing, right? It's a spokesman sort of thing. And in general, when it comes to Randy Savage or any wrestlers, John Cena, The Rock, maybe you've heard of them, doing things outside of wrestling puts more eyeballs on wrestling, puts more eyeballs on them. So of course, anything that can put them in the mainstream is a good idea. And I think it helps them. As far as the product is concerned, like a Slim Jim, there was a whole bunch of people that started buying it and started seeing it, and it became kind of part of the lexicon, so that it was in the back of their minds, this product, this would be a snack. And even if it was just subliminal, I think Slim Jim was happy to have that relationship and glad that they did. So I think it's a great idea. What are the drawbacks? The biggest drawback that comes to mind would be, what if one of these wrestlers does something, the person, not the wrestler, the human being behind the character does something that, makes the news for being bad, some sort of sexual harassment or that sort of thing, allegation. The brand's going to drop them. That's going to draw even more attention to whatever thing that they did. And that's not good. Similarly, co-branding, if Hulk Hogan, probably not a good example, if Kevin Nash was supporting the My Pillow guy, right? And he, in some people's minds, went off the deep end with his right-wing stuff and Trump supporting, then, that could make Kevin Nash look bad to half of his potential fans. You don't want to see right or left, Republican or Democrat, black or white. You just want to see green, right? So there's always the potential, and that's why a lot of those contracts with the wrestlers in a sponsorship deal will have morality clauses. It'll have a clause that allows the company to drop them in a second if they do something wrong. I think you saw it with Tiger Woods 10, 15 years ago, whenever that was, that he had his Thanksgiving event with his wife. He was losing people left and right, but they had morality clauses, and that was why they were able to do it. So that's the biggest drawback. I think there might be some others. Possibly if you foolishly, as a wrestler, signed an agreement that made you an exclusive endorser for a broad array of goods or services, and not just something very narrow, like, hey, you'll be the only watch endorser. Or will be the only company you endorse, that'd be fine. You just can't do other watches. You could do t-shirts and hats, but what if it was an apparel endorsement, and that apparel endorsement and all of that, was really just covering t-shirts, but somebody came to you for watches, for designer watches, and you couldn't do it because technically it's by apparel. So, but that's really, that's a drawback that can be addressed pretty easily and can be addressed up front and can be addressed with, good lawyering and good negotiating. Next question comes from Mark Keith. If you were to write a book and want to incorporate names of actual celebrities or names of a song in the case of band or a singer, what is and is not allowed legally? I know you can't actually include them as a character without first getting permission, but what about just mentioning the name? Yeah, so there's something in the law called referential fair use, and usually you'll see that in the trademark sense, but somewhat in the copyright sense as well. And what that is, hey, I'm not using this, I'm not profiting on it. It is not the basis of my book. It's not, I'm not trying to trade on the goodwill of Kiss or the Rolling Stones or whatever. I'm just referring to them in this story. And if it's factual or non-factual, and to what extent you use it will, of course, all matter, but you're allowed to refer to things by name and talk about them. There's rights of publicity, of course, you have to be kind of concerned with there. So If you were using images or pictures or things like that, that could be a problem. But referring to somebody by name, actual celebrities or the name of a song, yeah, generally it's not a problem. You can do it. As far as copyright is concerned, you could even use some of the lyrics in the song potentially. You have to look at the fair use doctrine and what is fair use under copyright. Copyright that it's going to look at, is it a fictional work or is a non-fictional work? If you're telling a biography, you're telling the story, a real story of somebody's life, you have to kind of tell the facts, but you want to make sure that it's vetted and they're telling facts. You're allowed to do that, just because it's a celebrity or a famous song or whatever doesn't mean you can't use it. In fact, you can use it because it's a fact that was a part of your life. So fair use is going to look at fiction or nonfiction. It's going to look at the substantiality. How much did you use? So if you're referring to a song and maybe want to include a line or two of lyrics, probably okay. We use the whole set of lyrics, that might be a problem. It's also going to look at, is it for profit? Is it not for profit? And it's going to look at something else that I'm blanking on, but that's the kind of analysis you go into. Generally speaking, it's going to be okay, especially if it's something that's in passing. But you always want to make sure that you're telling things factually, that maybe you're not putting people or things in a bad light, because all that'll do is open you up for potential litigation, defamation and this sort of thing. But you are allowed to use it and refer to real people and real things in books and in stories. Lauren Eason asks, could you educate me on how it's possible for indie wrestling promotions like GCW and such, and how they're able to play licensed music for their wrestlers without repercussions? But if it's a company like WWE and AEW, they have to pay for the rights. Yeah, that's an easy education. They're not allowed to, but they're just doing it. And it's really just a matter of eyeballs, right? Is WWE and AEW are on national TV and have, tens of thousands, hundreds of thousands, millions of people following them. And so somebody in that group is either going to drop the dime on them, or it's going to be found out on television somehow or another. A network executive or somebody's going to see it and start asking questions. Somebody like GCW, which is, great product, and I've gone to a number of their shows and enjoy it immensely. It's not hitting as many eyeballs. It also doesn't have the pockets, the deep pockets that a WWE or an AEW has. But I think it's a matter of time, really, until an ASCAP or a BMI, one of the music licensing entities and brokers, goes after them and sends them a nastygram. They'll send people around to shopping malls and restaurants and, to some extent churches and places like that to listen for music that's being played publicly that isn't allowed to be played. And then they get a nasty letter that says, hey, you need to license this, and, it's going to be $30,000 or whatever number they throw at you. You need to pay that because that license is retroactive. You need to tell us when else you used it. You need to give us all this, that, and the other, and never do it ever again. I've had those a number of times for clients. A lot of times it's been festivals, right? Just a local fair or something like that. And there's a cover band, and the cover band is playing some music, and they didn't get the rights to cover the music. And they'll get a nastygram, and the festival will get a nastygram as somebody who was a contributory infringer. They booked them, they paid them, so they're responsible too. And usually what happens is there's a negotiation and you get the fee knocked down significantly, you pay it and you move on. But that's really it. They're not allowed to do it. It's just they haven't been caught yet. And in my opinion, it's probably just a matter of time. Next question by Lauren Eason was, ever have any client relationships that jeopardized your personal relationship related with wrestling? Interesting question. And yes is the short answer, but it was really kind of short-lived and was really much ado about nothing. But it leads into the next question from our other Lauren Yaffe, and I'll kind of answer both at the same time. Lauren Yaffe asked about, I remember reading a story about a conflict between FTR and their use of the potential name Fear the Revolt and an independent faction called the Revolt. Can I talk about that? And yeah, most of that's public record. But the FTR guys, I think probably most of are clients and they're friends. I'm super friendly with them. And the Revolt guys there's been a few different people, I think, part of it, but one of them has helped with StarCast and is somebody I've drank with and hung out with and is a friend. And so it potentially got where there was this conflict between a friend on one side and clients, FTR, and friends on the other side. And I was concerned that it might affect my friendship. But he was very cool about it. I was like, look, I know you've got a job to do. You've got to represent your client. I don't, whatever happens. I don't take it personally. I'm not worried about it. It's business. So that was refreshing to hear. And it hasn't affected anything so far, I don't think. We'll find out next time we bump into each other, I guess. But the conflict was, when the Revival got released from the WWE, they had to come up with a new name because WWE owns the Revival. And they came up with FTR. And as most of you probably know, FTR was something that the Young Bucks were saying and kind of chirping at them when they were at different companies, and it was fuck the Revival. And so it just became FTR short for it. And the Revival then adopted it and was like, this is funny. This is hilarious. These are our friends. We're going to appropriate this for ourselves and have fun with it. So when they came into AEW, they thought, okay, let's be FTR. And the plan was FTR doesn't really mean any one thing in particular, maybe depending on storylines or how things happen. That'll change what FTR stands for. And the first thing that kind of came to mind was Fear the Revolt. Like they were revolting against the WWE. So it was more of a catchphrase and a temporary sort of thing, not necessarily the team name. And they said as much in interviews and all of that. And they had FTR already registered before they ever filed for Fear the Revolt. And the plan was, okay, maybe sometime down the road, we have, forget the referees. That's what it stands for, because we're having some conflict and the referees are part of the story. In any case, we filed the application for Fear the Revolt and all of a sudden get a cease and desist letter from the Revolt guys about, this is infringing the Revolt or Revolt trademark. And I talked to the FTR guys. I talked to, the people that I knew. Actually, we didn't get the cease and desist letter first, because if we had, I couldn't call my buddy directly. That'd be a breach of ethics. So before we got a cease and desist letter, I had a conversation with him because there was some chirping online and things like that, and said, hey, I just don't agree that there's a likelihood of confusion here. You have lots of express teams, right? Jurassic Express, Midnight Express, Rock and Roll Express. It's all the time in wrestling. There are trademarks that are being used and that have a common word or some overlap in words. And I think that's the case here. It's longer, it's different. And, it's this, there's no reason to do this and fight this out. And so I kind of brokered a deal where I agreed that I would do everybody's legal services. I'd help them get the Revolt trademark. This was all in a letter. I'm going to get ahead of myself. The call was over, seemed to have an agreement where I said, look, I'll do the legal services for you guys for free. I will get you the Revolt registered, work out any consent that is required between both parties. If any such thing is required by the trademark office, I don't think that it will be, but if it is, we'll do it. I'll make sure your fees, your government filing fees get paid. And probably can turn this into an angle for you guys on one of your shows, one of your regional shows or whatever. So I had a good call, got off the call, and didn't really hear anything for a while. That's when we got a cease and desist letter from the other attorney. The other attorney, is pounding on the table. This is infringement, and you're ruining this, and you're doing that. And we wrote back and said, made that same offer. Here's what we have already offered them. We disagree. We don't think that this is really an issue. We don't think there's a likelihood of confusion. Here's all the reasons why, including the fact that your clients haven't used their trademark properly. Sometimes they're the Revolt. Sometimes it's Revolt. Sometimes it's something else, other word combinations. So they may not have any rights at all, but assuming they do have some rights, there's not a likelihood of confusion. And so there was some kind of hand wringing and hand waving back and forth. And the FTR guys decided, this isn't worth it. This is silly. We're going to AEW. We're moving on to big and better things. We don't need to worry about some smaller independent wrestling stuff going on. So let's just move on. We're just going to be FTR. We won't worry about catchphrases and slogans and all of that. So, but the application had already been filed, and they said, we might pick it back up. Probably not, keep it alive and see what happens. Well, in the meantime, the Revolt guys hired some attorneys and, had that, whether it was the same or different, I don't recall, but had them file an application for registration of their trademark. And it went through the normal process in the trademark office. And what do you know, as Jim Cornette would say, look who won the pony. The Revolt got rejected, but it was not rejected in view of Fear the Revolt. So the trademark office and the trademark examining attorney looked at the record, looked at all Revolt inclusive trademarks in the wrestling space, and found no issue. They found issue with other Revolt things related to, I think it's production companies or music or things like that in the entertainment space, but not fear the revolt. So the USPTO basically backed up what I said all along, and the revolt guys ultimately didn't see it through. They let the application go abandoned. Probably because, at that point they had spent a couple grand dealing with attorneys to send in a cease and desist letter, and then, spent $1,000 or more to get the application on file. And then it was going to be thousands of dollars more to reply to it. And assuming that a single reply got it done, have then all the fees that come with that. So that's my guess. I don't know that, but I'm thinking the cost is probably what stopped him. But the takeaway here for me was I was right all along, and there wasn't a likelihood of confusion. The trademark office agreed, and it was much ado about nothing. And this is one of those situations. I say it all the time, even though I am a lawyer, and this is a case where the lawyers are going to be the only ones who win. So people are going to get paid, and it's going to be me, and it's going to be the guy on the other side, and in a situation that just didn't need to happen. And I still believe that today, but it did. That's life. Everybody's moved on. Everybody's doing well. Everybody's having success in their field. So in the end, not a big deal. And it didn't harm my friendship. Again, it's my job. He understood that. So all is right with the world. So I think that answers both Laurens. Brad Stanton asked, when a wrestler leaves an organization for another, where's the line between his or her old gimmick and extension of themselves? Obviously, The Undertaker or Kane are gimmicks, but Stone Cold, Scott Hall, Chris Jericho, Kevin Owens, Generation X, etc., they're in ways an exaggeration of their own personality. But if that's what made them popular in another organization, it could get complicated. Yeah, you're right. And it's not complicated probably because of why you think. It's complicated because the intellectual property that WWE owns, or AEW, or any company that has pretty mature and well-established contracts, they list their IP as not just names, but costumes, color combinations, hand gestures, slogans, sayings, chants. It's a paragraph, this long. For those listening, I raised my hand up 3 or 4 inches long of lines of text of what is intellectual property. So, nobody can stop Steve Austin from going out and, being a rugged, tough Texan son of a bitch and doing the damn thing. But as far as, maybe doing the middle fingers up on the top rope, getting his hands up the way he does, that could be a problem. Probably not. That's kind of a generic sort of thing, but DX, specifically the crotch chop and all of that, that's a very DX thing. That's a very WWE thing. And they claim ownership to it. So you can't stop somebody from being them. You can't stop them from having their own personality, but you might get into a place where you have to delineate the character from the person, right? And if it's pretty clear and everybody knows who Steve Austin is, in real life, then it could be said and argued. And I don't think WWE would try to say, you can't go do that for that other company because that's our character. Like, no, that's just me. And that, and there'll be a million people in line who will back that up. That's just me. But as far as costuming and hand gestures and things like that, yeah, that could be a problem. And that stuff you got to veer away from, Scott Hall and the toothpick and the Ayo and the crotch chop. All those things have been litigated or had a cease and desist letter. So you got to be careful of that stuff. Jared Bell asks, what's your thoughts and expectations on Conrad's upcoming 40th birthday bash in Vegas? As he's mentioned, you're going. That's a great question. And the truth is, I don't have much thought or much expectation other than, I guarantee we will be hanging out. There will be a swimming pool involved. There will be vodka involved, and there will be a lot of fellowshipping and hanging out and watching wrestling and, busting each other's chops and just chilling, having good food. No time when we've hung out and done things socially has there really been a plan like, all right, on this day we're going to go to this casino and we're going to do this thing or, whatever. No, it's just, we're going to go with the flow. We're going to hang out. We're going to have fun, and whatever whim strikes us, we'll get into it. So I imagine there'll be, like I said, a lot of great meals. There'll be much alcohol consumed and some gambling and just hanging out and fellowshipping with the boys. Rob asks, how can a wrestler have 90, I think that is meant to be 90-day non-compete when the company releases them? Besides the idea that they agreed to it and somewhere in their contract, how is it legal? Well, that you hit it right on the head, right? You can contract to do or not do anything, so long as it's legal or, not illegal, I should say. You can't have a contract related to illegal subject matter and things like that. But that's, non-competes are common. It's not just a wrestling thing. It's executives, it's engineers, any sort of job where there's a specific service being provided, or specific information that employee gets, or a skill set, or a very competitive market. They will have non-competes, right? And the idea behind non-competes, and it's pretty well litigated, is they have to be reasonable. And so they have to be reasonable in scope, and they have to be reasonable in geography, and they have to be reasonable in time. So you have to look at all three of those things, and all three of them have to be reasonable. Otherwise, it's something that can be litigated. And so the courts are pretty loath to tell people, well, yeah, you can't work in your chosen field, your scope, for 5 years. No, that's not going to happen. That's too long. It's going to have to be something far less than that, a year or two or less, depending on the nature of the work, the nature of the job. Geography, worldwide. No, not likely. Courts aren't going to uphold worldwide under most circumstances, because that's just too broad. You might get a surrounding area. You're probably not going to get the state. You might, depending on how big the city is, if it's Chicago, it might just be part of Chicago. Whereas if it were, Cleveland, you might get all of Cleveland. And then time, I think we already covered time period. You can't make it forever. You can't make it too long. And scope. So the scope, like Brock Lesnar was told, you can't do MMA, you can't do football, you can't do, I think it was all sports and things like this. I think they finally came to an agreement where football was okay, but combat sports weren't. So he wasn't able to do MMA at the time, and he sued, and there were lawsuits and all of this. And eventually they came to a settlement. He tried the football thing, got down to the last cut, as I understand it, didn't make the team, but he had to really sue and fight to get a resolution where he could maybe do a dance in Japan and maybe go to MMA. But all three of those have to be reasonable. It has to be reasonable. Otherwise, it won't be held up in court. So 90-day non-compete, it's really not that unreasonable. And they also, a lot of times, will get, a severance for that 90 days when they're let go. So, you're going to make pretty good money and really be able to sit at home and prepare and, lick your wounds and be ready for when you come out on the other side. Crush, Revscar, I don't know. I mispronounced it. Crush, anyway. Expanding on Rob's question, with the term, quote, independent contractor, how can a company use a person with that title, technically force that person to work any dates the company chooses, promise a person a set amount of time with said company and set amount of money for that said time, then legally breaks that contract with said independent contractor with all that time and money unfulfilled, and force a 90-day non-compete clause? But when an independent contractor breaks the contract, said person has to go through hoops to be able to make a living in that profession. Okay. So really what you're asking is, how can a company shit can a wrestler, but the wrestler can't break the contract? And that's easy, because that's what the contract says. And when you are, what's the golden rule? He who has the gold makes the rules. So, WWE has all the leverage and has all the bargaining power. They will say in court, they have said in court, they continue to say in court, that these are freely negotiated contracts. There's little to no truth in that. They're not freely negotiated. You cannot change a number of provisions in their very long contract. The things you might be able to negotiate, the dollars to an extent, the amount of time to an extent, and depending on where you are in the pecking order, the percentage of your royalties. But that's about it. Travel, I guess you can negotiate that. I want first class travel and I want you to pay for it, or I want a bus, or whatever it is. Those are things that can be negotiated. That just comes down to money. When it comes down to rights, I'm not familiar with them ever changing much anything. They're not going to allow you to change the venue where you have to dispute these things. That's always going to be Connecticut. You're not going to be able to say, I'm not an independent contractor. That is non-negotiable. Most of the other things you just can't negotiate. So it's not freely negotiated. They give you a contract. And as I understand it, as I've heard from numerous people from their own mouths, if you go and you get the contract, and the contract says in there, hey, you agree that you've talked to an attorney and gotten good advice, and WWE encourages you to talk to an attorney, and you should do that and make sure that you understand everything in here. But then when you actually get an attorney, they are not happy about it, and they will stall and cold shoulder you, and you kind of get some heat for it. So they tell you to do it in the contract. They tell you they want you to do it in the contract, but in practice, they kind of shit on you for doing it. So they're not freely negotiated at all. And so that means they're very one-sided. They're very slanted in favor of WWE. And, to an extent, that goes for all promotions. And that goes for Impact, AEW, NWA, Ring of Honor, all of them. It's slanted to the company. But I use WWE as the example because you're not really going to get very far in pushing back on any of those things in the contract. So while you are an independent contractor, it's not a contract agreement. It's more or less a, hey, we will keep you employed. Employee is a colloquial term. We will keep you contracted for up to this amount of time, but we can let you go for any and all reasons. And those include, we don't think you look good anymore. We don't think that your in-ring skills are as good as they used to be. It's really almost like an at-will independent contractor. That is, they can fire you for any reason or no reason at all. And so that's why they can do it. And meanwhile, the independent contractor, the wrestler on their side of things, can't, is because it doesn't say that they can. They are locked in and it's exclusive, and they are only allowed to wrestle and make appearances and do these things for this company during the term of the contract and 90 days thereafter. So that's it. It's all by contract. I by no means would I say it's fair, but if I put on my wrestling promoter hat, I would want the same thing, right? I would want to have the ability to let somebody go at any point for any reason. It doesn't have to be a good reason. And not owe them money on the backside, because we're talking about personal services contracts, right? And if you lock somebody in and you have to pay them those dates and you have to pay them this time and all of that, and they get it hurt or are faking being hurt or being difficult, and maybe not to the point of insubordination or something like that, but they're just a poison in the locker room, you'd want to let them go. And you don't necessarily want to have them sitting at home making a ton of money and not doing anything. So I get it. I get why they have the ability to let them go and not have to pay up on the full contract other than the 90-day non-compete. But let's remember, there's a lot of people who work for WWE, who have worked for WWE and AEW, who have gotten hurt and have had pretty bad injuries, torn ACLs, torn quadriceps, this sort of thing. And they pay them. They pay them to stay home. They pay to have the things fixed and to let them get their surgeries. And so you got to look at the good and the bad is my point. They have taken care of plenty of people. They do the rehab bit after people have left. Could they do more? Probably. They probably could, just like the NFL's been forced to do more, not because they wanted to, but they do a lot, and they do a lot to help wrestlers and take care of people that are hurt or pregnant, for example. And so it's not always all bad. It's not always in a bad light, and they sometimes do good. But the short answer is it's because of the contract. That's what the contract says. Our next question is from Dennis Hardy. He says, hello, I was wondering if my wife and I open a home daycare, if I should get an LLC, or would you recommend something else? If so, how would I go about getting one? So when it comes to home daycares, there's a lot of licensing that goes into it, and I don't know much about it, but it is all dictated by the state. And so you'll want to look into that. That's a big deal because there's a lot of things you have to have in place, right? A lot of safety things, a lot of, I was on the board of a daycare, not a home daycare, but an early learning center where my kids went when they were little. And there's a lot of regulation and inspection and stuff that goes into it, entrances and exits and lights and, tip hazards and all sorts of things. The way that things get cleaned, the way that your hands get cleaned and all of that. It might be different for home daycare. I'm not sure. But I would check there first. Certainly you want something in place. If it's not if it's not required by the state, an LLC might be the way to go, but a corporation or an S corp or something might be the way you have to go, or might be worth going to, if for no other reason than liability, right? We're talking about kids, and I can't think of many, if any, more sympathetic characters or, plaintiffs in a court in front of a jury than kids. So, stuff happens, accidents happen, whether it's negligence or gross negligence or recklessness or any of these things, doesn't really matter. Nobody likes to see kids get hurt. That's something that everybody can agree on. Even in prison, there's a pecking order, and the pedophiles and all that are at the bottom. Nobody likes people messing with kids. So you want to have liability put on an entity and not on you or your home or your wife. So I'd start there. If you've got a tax person, I'd talk with them as well and see what they recommend as far as what sort of entity to form. I think you can probably find some, look at some well-known daycares and things like that in your area, and look at the Secretary of State's office, do a search by the business name, and, try daycare, childcare, whatever, and see what those people do, right? See if they're forming LLCs or corps or whatever else, and go that route. But if you want to go about doing it, there's lots of attorneys that can help you do it and help you form them. It's generally not that expensive. Because there's more than one person, you probably will want to have a pretty decent operating agreement in place. Yeah, I think that's, I would do some due diligence yourself on the licensing side. I would look and see what other people have done with your state Secretary of State's office. And then I'd probably reach out to a local attorney. It's really not that expensive, usually a few $100, maybe up to $1,000, but it's not that expensive, and something you're going to want to do to insulate yourself and your assets from liability. Next question comes from Ari Rosenbaum. If I take a picture of a wrestler at a show, and assuming I don't live in a state that recognizes a right of publicity, like in New York or California, can I use that image for my own commercial endeavor, such as selling a photo or making an NFT? Well, that's a big assumption that the state doesn't recognize a right of publicity. Almost all states do. And to the extent that a state doesn't, it's usually that they haven't said, we don't recognize the right of publicity. It's usually they just haven't dealt with it. And so it's a matter of first impression. And it's usually just ripe for some litigation to happen and for the court to say something and then put the common law in place, since it's not there by statute. Is there anything to be done absent a right of publicity? Probably not. But I think you're going to be hard pressed to find a state that doesn't have it or that wouldn't find it. That no court really wants celebrities' likenesses and things like that profiting other people. They'd say, well, wait a minute, that's not exactly fair to the person whose likeness, the value is derived from. Plus, in an internet world, in NFTs and things like this, where we're stringing together blockchain and it can be accessed by anybody in any state, presumably you'd have to keep everything locked into the one state in which you're in to be able to control it, because once it gets out of that state, now you've probably created sufficient minimum contacts to be hauled into court in that state. So I just can't imagine a case where that's allowed. Yeah, you're allowed to take a picture, you're allowed to have the picture, and that you're allowed to have that picture for your own personal use, but you're, display it in your house or, show it to family and friends, maybe even put it on social media. But as far as using it to profit from, no, I'd recommend very strongly against doing that. Brian Stevens asked, hey, Mike, I don't know if you've ever answered this question, but I'm entering my third year of law school. As a big sports fan and a lifelong wrestling fan, I've recently been interested in getting into sports and entertainment law. As the beloved Gimmick attorney, thanks, Brian, do you have any advice for someone like me with regard to getting into the business and or anything else you can share to that end? Yeah, I think it's probably advice that I would give anybody in any particular area, and that's be persistent and, work everything you can. My own personal story was I came up with a plan and I implemented that plan. And that plan was, I'm going to throw everything at the wall that I can and see what sticks. I'm going to try different things. And you can't be afraid of no. I try to look at no as not a no, but a not yet or not right now. And so to that end, persistence, it really helped. And I was persistent in following up with Conrad whenever he indicated, yeah, I'm interested in doing some stuff. And, I'd like to have your help. Oh, he's a busy guy, right? I didn't just assume that, he didn't get back to me. And so he's really not interested. He's blowing me off. I kept following up and, I was friendly about it and said, I'm going to keep following up until you tell me not to. I'm going to be the squeaky wheel, and either I'll get the grease or you'll tell me to go away. And either way, that's fine. So that's, I think, what you're going to have to do. There's the story of a guy I went to law school with who was on an airplane ride, flying. I think he was flying home from school, maybe a break or something. I don't remember what. And he happened to sit next to, and I'm an idiot for forgetting, but he sat next to a super agent in sports and got to talking to him. And they just struck up a conversation and they exchanged information. And this super agent got him in touch with some people, and he got in with, I think the Cavs was the first team that he went to. And now he's the GM of the Clippers. So he worked his way up in the organization with the Cavs, ended up getting a job with the Thunder, was at the Thunder for a while, and I think was an assistant GM there, and then, moved on to the Clippers. So he bounced around the NBA, and it was all by luck. It was all by happenstance, being passionate about something, knowing something about it, and, taking advantage of an opportunity. A lot of people, I think, get crippled by a fear of being told no, or a fear of rejection. But, buddy, I'm here to tell you there's going to be a lot of no's, and there's going to be a lot of rejection, and you can't let it get you down. Be disappointed, sure. Maybe even you get upset by it, but, learn from it and move on and keep trying. I think that's the best you can do. You might have to do some unpaid internships, right? You might have to work double duty for a while and have a real job that you don't necessarily like while you try to push things in the sports and entertainment law area. You should maximize the grades and all of that you can get in law school to try to impress a firm that's in a place where sports and entertainment law would be a big deal. So you're talking about your Nashvilles, your Los Angeleses, your New York, and this sort of thing. You'll have entertainment and sports law groups everywhere, but some places are bigger than others. So do some research, find out where those places are, see if you can get a clerkship there, or, volunteer there or something like that if you can't get hired there. But, just keep poking around, keep trying, keep your head up. Persistence is the game. Good luck. Matthew asks, could you provide some explanation on the issue WWE has with quote unquote superstars of wrestling? Why is it blurred out on episodes of primetime on the network, and there are no episodes from 90 to 92? The best era, in my opinion. Well, that's interesting. There was a trademark conflict with WWE and somebody else, and the short answer is WWE came second. So if you've listened to me harp about trademarks or any of my other episodes, I talked about them quite a bit. And first to use has superior rights. So WWE had filed for a trademark, as I recall, and they didn't respond to whatever rejections, and they let it go abandoned. And then later on, 6 or 7 years, I think that was 1986, 1987, maybe. And sometime later, a guy named Albert Patterson filed in 1993. Albert Patterson had been using his trademark since 1979. So he had sat on it and didn't get it registered for, 14 years. And when he, did that, his use predated WWE's. WWE's was not until the 80s. So at that point, his application moved through and he got a registration. And he had it trademarked. So there was litigation, and they lost, quite frankly. And we'll have flash up on the screen here. What's interesting about this, and I don't know this for sure, but I think what WWE's argument was, well, his use of the trademark was with these other letters in this design, and our WWE's use is with WWF or whatever else they used, or without that design. That's a big difference, and it's kind of descriptive, and it's not something that can be protective. Well, they lost that, and so as part of that, and because there was no settlement with Mr. Patterson, they have to blur it out because it's trademark infringement otherwise. If you remember back when I talked about getting the F out and they lost the F, they had to blur that out as well for a long time, until some other appeals and other fights and other things like that. And the World Wildlife Foundation said, okay, archival, you're allowed to do it, you're allowed to use it, and that's why. As far as why WWE doesn't have those 3 years in, couldn't tell you. My guess is it's just something they haven't put up there. There's probably not a specific reason, I would think, but who knows? But there's your answer. It was a trademark dispute, and they lost. Michael B. Thompson asks, could you take Stephen P. New in a courtroom brawl? That's a funny question. Actually, Stephen and I just had a half an hour long conversation last week, I think, maybe 2 weeks ago. Nice guy. I very much enjoyed talking to him. And I think people will find a lot of times, and can be irritating to our clients, is that it's business, right? I talked about this earlier in a personal situation. It's business. And I can respect and like an attorney on the other side, and even go out and have beers with them and, yuck it up and talk wrestling and whatever, as long as we're not talking about client stuff. From the outside, from somebody who's really passionate and suing or being sued, that doesn't look good. So usually don't do it while something is ongoing. But after the fact, all the time that happens, right? And having a good relationship and having a trusting relationship with opposing counsel can be very helpful, and it can make it a much easier, cleaner, more painless fight. But sometimes you get people that aren't professional and that are real sons of bitches, and you just absolutely don't like that person and don't like him inside of the court or outside of the court. As far as a courtroom brawl, I don't know if you're talking about physically or legally, but Steven is a litigator, a very experienced litigator. So he'd probably, I wouldn't be surprised if he took me down in litigation. I'm not a litigator. I have litigated. I've won cases. I've taken cases to the jury. It's something I could do and have been asked to do. As far as internal to the firm and external to the firm, it's not something I want to do. It's a very different lifestyle. It's a very different mindset. There's, long periods of not much happening, and then a bunch of stuff gets ramped up and it's just high stress for weeks or months. And then you got to kind of decompress after getting all jacked up and jazzed up with the fight in court. If we're talking about physically, I haven't met Steven yet in person. I have to believe I'm a lot bigger than him, height wise anyway, but he's got a show that he's sponsoring down in West Virginia. I think coming up soon. I'm going to try to get down there to, hang out and have a beer with him and just shoot the shit. So, nothing but mutual admiration between the two of us. And I don't think either of us is looking to get into a fight anytime soon. Lenny asks a couple questions. What's your favorite WrestleMania and or WrestleMania match from when you were a kid? So many. I don't dedicate a lot of time to, and never have, to which WrestleMania is which and dates and this, that, and the other. But what I can tell you is this. As a kid, when my folks got divorced, I would get to see my dad every couple weekends and a couple weeks out of the year. And that was something that he and I watched, not because he necessarily liked it. He didn't. But he supported me liking it, right? And so he would get me for my birthdays and things like that. He'd get a pay-per-view. He didn't have the magic black box that sat on top of the TV. So we'd have to go to my aunt and uncle's house. And so that's how I kind of kept a relationship with my aunt and uncle. And it was WrestleMania 6 was a big one for me because I was such a Hulk Hogan mark. And I remember being at my aunt and uncle's house and watching Hogan and Warrior and like just being devastated that Hogan lost. I hated it. That I liked Ultimate Warrior just fine, but I couldn't believe that my hero Hulk Hogan won. And part of that kind of story and stuff that my dad did as far as wrestling was concerned is he got me subscriptions to the magazine. So I got to meet Hulk Hogan once and we talked, and I had my son. I've got a picture of my wife and me and my son meeting him. And my son is about 1 year old at the time. And he just can't figure this guy out. He can't figure out how tall he is and how tan he is. And he's just got this amazed look on his face. I'll, if I can find the digital version of the picture, I'll shoot it up so you guys can see it here too. But and I told him, I was like, man, it's an honor to meet you. Thank you for all the years of entertainment and all that. Like, there were very few birthdays and Christmases growing up where Hulk Hogan wasn't a part of it. And so that meant a lot to me. So, that's one that really sticks out because there's so many details around it that I remember. But Hogan and Andre, that was a big one. Anytime the Rockers were involved, that was my tag team. That was my jam. So I love seeing them in big matches and always felt that they didn't get their due. And I think some would argue they probably didn't. It was a pretty popular, pretty talented team. And, they didn't get a chance at the belt before they broke off. And then, Shawn Michaels became one of the greatest performers of all time. Lenny also asks, have you found that most wrestlers are eager to work with you on trademarking their IP, or do some feel it's not worth the cost or effort? I would say it's overwhelmingly that people are eager to do it and want to do it and want to protect it. I would say if there's a scale of eagerness, the top of the scale is people who have been under the thumb of New York and know that whatever they built, whatever they put into it, whatever they did for however amount of time, 2 years, 5 years, 10 years, they don't get it. They don't own it. They got nothing. So they want to own their stuff and they want to own it moving forward. And there's precedent for having a brand, getting it over somewhere else, going back or going to New York and getting to keep your brand. AJ Styles, for example. There's plenty of people. Dr. Death. There's lots of guys and gals that were famous somewhere else and went to the Fed and were able to keep their IP. So at the top of the eagerness is usually people who are former WWE. They don't want to be under that thumb again. They don't want to be under anybody else's thumb in any other organization. They're going to own their stuff, and away they go. Do some feel it's not worth the cost or effort? Not many. Usually if there's, I can really only think of one who felt that it just wasn't worthwhile. And I think it was not really that it wasn't worth the cost or effort. It's just I'm going to use my legal name. And, if I have to go somewhere else and pick another, moniker, a big sexy or a, whatever, I'm still going to be, it's not Kevin Nash, but I'm still going to be Kevin Nash no matter what. And if I can't be Big Sexy, great. I'll be Big Daddy Cool. Oh, I can't be Big Daddy Cool. Then I'll be, whatever. But that's few and far between. A lot of people, are more and more lower level talent. And I don't mean that in an insulting way. I should say new talent who maybe aren't at the top of the pay scale are eager to do it. But they're not at the top of the pay scale. So while it is just a few $1,000s and it's not that expensive, when you're scraping and digging and having to make towns and do all those things that we hear about, like if you're listening to Arn and his stories, like he had to deal with, that's an expensive venture to go down right now. And so they kind of put it off, but it's not that they don't want to, it's just a cost thing. Then he asks, if you were advising the Ultimate Warrior back in the day when he was having his WWF dispute, would you have recommended that he do what he ultimately did, legally changing his name to Warrior? I think that would be on a platter of things that I would have suggested to Jim. The bigger issue for me, and sometimes I have to ask clients to swallow a poison pill that doesn't taste good, but will get them what they want. Right. And so I mentioned this before, there's the practical side and there's the legal side. The practical side is, you're going to fight a long time and you're going to lose a lot of money. And like I said earlier, who's going to win? The lawyers are going to win. And if you want to fight on principle, or if you want to fight because it's the right thing to do, or, you're fighting because of emotion, that's all expensive. You have to kind of be cold and detached and make a business decision about everything. And so that's what I feel my job is. I don't try to talk anybody into or out of anything. I tell them what their options are. I tell them the pluses and minuses, the ups and downs with all of those options. I advise them what, the cost potentially could be. And then if they want it, I give them my recommendation of what I would do if I were them. But ultimately, it's pun intended. Ultimately, it's their decision. So for Warrior, I think, and you may have tried this. I don't know. Maybe this is one we'll dig into later. He was Dingo Warrior before he ever got there. There was pretty much no chance he was going to own Ultimate Warrior. So going by Warrior probably would have been fine and was fine. And legally changing his name, of course, you can use your name legally and be Warrior. That is an option. That seems a bit extreme. I think he had some arguments to be made or deals to be stricken that he had been Warrior or Dingo Warrior or whatever else he was in prior territories before getting to WWE or WWF, and maybe even attacked WWF's use of Ultimate Warriors being infringing on Dingo Warrior or something else, right? And I'm not saying that I would have recommended, hey, sue and try this and fight this and really dig in, but at least muddies the water, right? And if you can muddy the water and get them just to take just a half step back to say, is this really worth the fight? Can we resolve this? Then it could have been resolved. But I think there were a lot of hurt feelings. I think there was a lot of emotion in this. I think there was a lot of principle involved, and that's why it escalated the way it did. But would I have advised him on that? Yeah, I would have absolutely advised that's an option. That's something you can do. It seems extreme. It has its own potential issues, but it's one of many options that you have. Last question from Lenny is, would you have advised that Vern Gagne fight the state of Minnesota on their eminent domain claim on his property? Any other approach you could have taken other than giving in? Ooh, eminent domain's tough. That's a big power that states and governments have to be able to take people's property away. And I don't know that you can much fight it usually. I'm not an eminent domain attorney, but my understanding is, boy, it's tough. And it even expanded. I want to say it was right after I was in law school, maybe while I was in law school, but not all that long ago. There were some big changes that said, a reason for eminent domain that you could take somebody's property away. So usually, let me take a step back. You would have eminent domain where, say you have all these acres of land, or maybe just an acre of land, and you're up against some roads, and the roads need to be widened. They're just too narrow. There's too many accidents. There's too whatever. The government can come in and take a portion of your land to widen the roads. There's public safety concerns. There's lots of policy reasons and all of this, and you'll get compensated for it, right? You'll get compensated for the land they take. So they're allowed to take land. Maybe it's a public utility. Hey, we have to run this power line or gas line or whatever that's going to, supply the rest of the state. And we're going to have to come in on your property, assuming that the gas company or whomever didn't already have an easement and right to do that. They can take property away, but they have to compensate you for it. So I think for Vern, the fight might have been the cost, whatever he got reimbursed, that maybe the fight could have been to get a little more out of him. But usually I just don't know enough about his particular situation. Usually that sort of thing is tough to fight and tough to win. It can be done. But as I was going to say, the law changed a little bit or expanded a little bit where economic interests became a reason that governments could take some land by eminent domain. So, this new, Walmart distribution center wants to come in, and it's going to be 1,000 jobs, 1,500 jobs, and hundreds of thousands, millions, tens of millions of tax dollars are going to come in here. That's a good reason for a government to be able to say, hey, we're going to take this land by eminent domain and compensate you for it because this is going to have this huge impact. So I still think that's good law, but I'm not certain. Again, I'm not an eminent domain attorney, but those are tough situations to fight, and you're fighting the man, right? And you'd like to think that the man wouldn't be vindictive and maybe start screwing with other parts of your life, but it's possible, right? Oh, you're fighting us on this? Well, look who just got audited. Not saying it would happen, but I think we know it could happen. So any other approach you could have taken? I think just try to squeeze every last dime out of them and, move on as much as it stinks. If it's for one of those reasons that I think it was. Luis Mendoza has our last questions here. And Luis asks, what's your estimate on how much Tony Khan pays for Tarzan Boy and Wild Thing? Do they have to pay every time the person comes out or something once a year? It depends. It's all by contract. As I understand it, I think Tony Khan bought the Tarzan Boy song and owns the distribution and publication rights. So whatever that cost, it is what it cost. It's whatever was negotiated. I don't have a good idea. I'd have to see the data of how many downloads, how long has it been played, how much has it been licensed in the last few years, what kind of fees and things are they getting from ASCAP and BMI and those sorts of clearinghouses. And I just don't know. But if he does own it, whatever he paid for it, it's his now. And I think that's what happened. As far as Wild Thing for Mox, that is, again, going to be a license. I don't think he bought that. I'm pretty confident he didn't. I know that John wanted that song because it was an homage to the Japanese death matches and exploding barbed wire matches and things like that, and how that was an entrance song. I'm guessing that's probably by per use or maybe per year. Any way you can dream up that they carved up that license, they could do it. So it could be, it's going to be, $1,000 every time you use it, no matter where you use it, be it a house show, pay-per-view, or a TV show, or it could just be a flat fee. We're going to give you, $10 million and we get to use it for the year anyway, in every way we want. And you usually have language in there that says, if we reproduce this, have a streaming service or make DVDs or whatever, we're allowed to keep the song as part of it. The other part of that will say, but you can't pull the song out and use it separately, right? It can be part of that whole work, the whole work being the entrance for that match or for that Dynamite or for that Double or Nothing or whatever it is. But you can't take the song out and then, plug it into the entrance for somebody else. It has to be the way it was originally intended and what it was originally licensed for. So do I have an estimate? No, I don't know the numbers. Do they pay every time? Or is it once a year? It depends on what they negotiated. It can be any of those things. It can be a one-time thing. It can be a 1 month thing. It can be a 1 year thing. It can be whatever, whatever they wanted it to be. My guess would be, and I don't know, that it was probably a year or less. And my guess is less. It'll kind of wrap up with John whatever angle he's currently working on wraps up. But what do I know? Maybe Tony did buy it and they'll use it forever for John. Can you elaborate on how WWE was able to try and stop the Too Sweet symbol by the Bullet Club? Yes. So, there's been a lot of back and forth on that online about whether that was a real thing, whether there was actually a cease and desist letter sent, or whether there wasn't. But as I mentioned earlier, the WWE contracts and everybody's contracts talk about IP, and hand gestures is one of them. And so what WWE was trying to say was that hand gesture is our IP. It's our trademark. It's our symbol related to wrestling, and nobody outside of our company can use it. I think there's probably pretty good arguments that it was being done well before that, in other places by other people. But they were saying, I guess they took it over from WCW, right? When Hall and Nash invaded and they started doing things like that, and with Hogan and NWO, it ties back to that. So they might be right that they do own that hand gesture, that trademark, in the wrestling space based on the WCW use. But if there was use prior to that, in the wrestling space, then, there's an argument that that they went a little too crazy in sending a letter if they actually did send a letter. So I hope that answers everybody's questions. Had some really good ones this time. Well, not that they weren't good last time, they were, but I appreciate it. And I thank you guys for checking out the show, and look forward to coming back at you again next month. Have a good one.